Welcome to Money and Purpose, a podcast about intentional wealth and aligning your money with what is most important to you. I'm Marianne Poon, CFA charter holder and financial advisor. Today, I'm joined by Micah Snitzer, an estate planning attorney at Pasternak and Fidis in the Maryland and DC area. Micah has been recognized multiple times as a top estate planning attorney and super lawyer in the region. Today, we're talking about why we all procrastinate on wills and trusts, what can go wrong when we do, and the surprising relief people feel once it's over. Hi, Micah. Thank you so much for joining me today. It's great to have you.
Thank you, Marianne, for inviting me. It's a pleasure to be here.
Do you want to start off by telling us about your practice at Pasternak and Fidis and the clients you typically work with?
Yeah, there's two parts of our practice. The first part is estate planning, and that's helping clients set up wills, trusts, on how to provide for their loved ones when they pass. And the second part of our practice is postmortem administration, so estate and trust administration. The type of clients ranges. Our mean client has about $10 million, but we will help clients with, after they have $1 million to well over hundreds of millions of dollars.
So a lot of people procrastinate updating their wills and trusts and estate documents or getting them in the first place or working with a financial advisor. And you and I were talking about this earlier. Like, why is this so hard? Is it because there's so many decisions to make? Are they difficult decisions to think about? Is it because the consequences are not presented clearly?
Everyone's unique, right? Everyone has different things that are hurdles for them, that are harder for them. I think the first thing is this information gathering, that is, every time I go to the doctor's office and I have to complete the questionnaire, it is like this cringe moment you have. And so just getting over that, the documents you need to gather to have account statements, life insurance policies, that is one barrier. And then I do think there can be decision fatigue. A good estate planning attorney is going to help guide the client so that they have options, but not too many options. But even within that narrow scope of options, sometimes it's hard for clients to make up a decision, and it can be for a variety of reasons. Sometimes they feel that they're choosing the least bad option, and so that can be one of the things that's very hard because they don't know who should be their fiduciary. That should be their son, their daughter, or brother. They have a hard time sometimes with those types of decisions. And so that's one of the things that comes up often. The best we can do is to help the client understand that ultimately they need to make a decision. Here are the pros and cons of those decisions. It's up to you what you want, but doing nothing is doing disservice to you. And so that's what I try to beat home, is that you got to make a decision, and the further you delay it, it only gets harder and harder. It's like procrastinating with anything. If you don't do the dishes, they just continue to pile up. And so it's just better to do it as soon as possible. Most people seem to understand that, but some people it just is emotionally taxing.
It's hard to have to make all these decisions about what happens to you when you die. That's like the least fun thing to do, right?
Yeah. And actually, the thing that I find that is the most challenging for clients is the Advanced Healthcare Directive, their end of life wishes regarding medical care. Even though they don't want life-sustaining treatment, or they don't want artificial nutrition, or just saying it out loud, putting it on paper, is because you're confronting your mortality is very, very difficult and emotional. And it's one of the documents I find that clients sometimes have to come back because they're not able to sign their document at the meeting, unfortunately, because it's too emotional.
Do you think that it's easier to get your will done earlier in your life, just to knock out having to think about that? And then when you have to update it, it's easier to make those kind of decisions rather than, you're 80 and you're like, I have to think about my mortality.
100%, because for whatever reason, you're more confident when you're younger. And so people are able to make a decision, even if they're not 100% sure with it. Oh, I can revisit it. As you're confronting your mortality more. And so it definitely is where people, when they're getting into their 80s and 90s, can get stuck, where they know they don't like what they have under their will. They know they want to change it. You present different options for them, but each one, they have pros and cons on it, and they can't just pick the best of those options. And so it just gets harder with each year. You become a little bit more indecisive. And so it's something I really try with my elderly clients to set time limits on, okay, you need to take a pause, but let's give it a week, a month, and then let's make a decision so that you're not left with an estate plan that you don't like. Let's get it to a better place.
So, what makes a good estate plan and what makes a good estate planning attorney?
Well, yeah, one of the things that I think it's important for clients to know about hiring an estate planning attorney or any type of professional in their life is you get what you pay for. Generally, when you're going to do an online will that costs $50, right? There's a reason why it costs $50 in that it may technically get the money where you're intended to your spouse or kids, but maybe it does it in a very clunky way. It is really important to just kind of be cognizant that when you're doing your estate plan, this is going to be controlling your assets. And so how much you want to invest in making sure your wishes are fulfilled. And if you're going to do it on the cheap, it could work out fine. But often we find when we're looking at these online wills that they're filled with holes. And create unintended consequences that make administering them a nightmare and don't fill the client's intended wishes as they expected.
These online will creators, estate plan creators, they're built for the general masses. They're trying to get the average of catching everything. But, humans are not like that. Our relationships are all different. Our assets are all different. So even something like the power of attorney, for example, I've seen in one of your wills is that both kids can step in at the same time, but act independently. And that seems very useful if, the brother's going to go take care of the credit cards and the sister's going to go pay the nursing homes. So those things are examples of clauses that you just can't get in a cookie cutter will.
Yeah, and that really is because, like you said, we're humans. We all are different, unique, and you need someone to help flesh that out. And having some sort of pre-generated software to ask you questions isn't gonna see your facial reaction when you say, "Would you want your kids to serve together?" It's not gonna be able to decipher what your intent is. And so that's why you want to have an estate planning attorney help guide you through that process. A good estate plan is something where you're meeting the client's objectives and goals, not just now, but for the next 5 years or so. And it even can grow with the client so that in 5, 10 years from now, that estate plan is still serving the client well. And a good estate planning attorney is someone who is able to advise the client on where they are now, where they want to go, and helping them flesh out what things make sense to worry about and what things do not.
So I help sometimes adult children manage their parents' finances. When you see adult children come to you trying to help their aging parents get organized, what does that look like?
It's always a tricky situation because you want to make sure the parent knows this is what they want. They want the child to be involved, but you always want to just confirm that with the parent that this is their intent. And then it can be great because what the child can do is what you want to do with any estate plan is get accurate and precise financial information. And that requires gathering account statements. And so the adult child can help with that. And so having that child there who's able to help with this process and get mom and dad's estate plan in order is not only helpful for the child to have peace of mind knowing that everything's in order and I'm serving as fiduciary, but mom and dad really appreciate it because they know my estate plan is in order, it's consistent with my wishes, and my child who's going to be doing all this work knows my attorney. They have a relationship now. Everyone, all the parties understand what's expected to happen under the terms of mom's dad's will, trust, powers of attorney, healthcare documents. So that's just a very helpful process.
For all clients, one of the first things I do is get a comprehensive financial inventory, and that takes a lot of work. How useful is it when somebody is able to show up with that versus not?
It's just how precise of advice do you want to have? Because many people don't understand how their assets will pass at death. And if you don't have account statements and accurate asset information, your will could say all my assets go to my wife at my death, but you have retitled all your accounts so that they're jointly titled with your son, and you pass away, then all your accounts will pass to your son by rights of survivorship outside the terms of your will. And so it doesn't matter what your will says. because you've titled your assets all jointly with your son, and that's how they're going to pass if you predecease your son. Or you designated your ex-wife as the primary beneficiary of your retirement accounts, and you forgot to update them after the divorce. People do this all the time, and they forget to update their beneficiary designations. Your attorney can tell you what you should do and the way your assets should pass in accordance with the terms of your will. But if you don't update the beneficiary designations accordingly, and your attorney's not aware of that fact, then there's going to lead to unintended results that you don't want.
I think people are often surprised that beneficiary designations supersede the will. And so it's very important to keep those updated. And I like to do an annual review of all the accounts and make sure all the beneficiaries are titled how they want to and it's consistent with the will. And sometimes they just mysteriously disappear. I don't know what happens.
Well,
Like people are like, I swear I updated those. And then 5 years later, they're not there anymore.
that's why when I had the pleasure of working with someone like you, a financial advisor like you, Marianne, to have that team approach where you have the financial advisor helping the clients with titling of their assets, with beneficiary designations to make sure they're consistent with their wishes. And on that second point, there are sometimes these glitches that happen in financial institutions where you think you filed a beneficiary designation form, they have no record of this. And there was a big example of this in, I think it was 2020 or 2021 with TSP, where they lost a lot of the recorded contingent beneficiaries of people's retirement accounts at TSP. So sometimes these things happen. Sometimes you send a beneficiary form and it's rejected, and you forget, you get a notice in the mail saying that your beneficiary form was rejected because you didn't sign it, you didn't date it, whatever reason, and you get this notice in the mail, and you, like other things you get in the mail, you just toss it away, and you don't notice that Fidelity never updated your IRA because you forgot to sign the form.
That must make your job very interesting.
It
That's
does.
part of it.
It does, but it's also, one of the rewarding parts, because when we do get this information and you do tell clients, hey, did you know you have your ex-wife designated as primary beneficiary of your IRA? I don't think you want to do that. They're always like, I totally forgot. Thank you for telling me that. I'm going to do that right now. Hopefully they do. And so, but having that financial advisor there also, it just makes it so much easier to make sure, because now I've told both the client and the financial advisor, and the financial advisor is on it and making sure, staying on the client so that we can work as a team to make sure it happens. And so
Right.
that having that team approach really ensures that the client's estate plan gets implemented on as far as asset titling and beneficiary designations. Most importantly, it gets good results for the client.
Yes. So beyond wills and trusts, what documents do you think people often overlook?
Well, so there's powers of attorney, and some people would call this financial powers of attorney. And that's the document in which you appoint an attorney in fact or a financial agent to manage your financial affairs if you're unable to do so. And so a will is only effective once you're deceased. The power of attorney is effective immediately once you're not able to act. And so that's one of the key documents that people sometimes neglect and don't think about. The other one is what's called we refer to as an advanced healthcare directive. Some people refer to it as a living will. It's where you're going to appoint healthcare agents to manage your healthcare if you're not able to do so. And you're also indicating certain end-of-life wishes. You want artificial hydration and nutrition, do you want life-sustaining treatment, or you don't want it? And that's a very essential document. If you think about there's a famous Terry Schiavo case of her not having an advanced directive, and they're being torn of what to do. And so having those types of documents, the power of attorney, providing one who can control your assets if something happens to you and you're alive, and the advanced healthcare directive, not one appointing a healthcare agent, but the second part of it is it's a kindness to your healthcare agents when you indicate what your wishes are, your end of life wishes are, so that they know what they are. Otherwise, they can be left wondering, does mom and dad want to be on a ventilator for years in a vegetative state or not? And so having those types of decisions helps your fiduciaries.
So that they can pull the plug without feeling guilty.
That's right, because it's not because they're just a conduit. Their wishes are helping facilitate their wishes. You're not the one actually directing that. It's the principal who's directed that. You're just their agent.
I think people underestimate the power of attorneys also because if you're unable to make a decision and you're still alive, somebody can just step in and start paying your bills for you and access your bank account. So, what happens if you're incapacitated and there is no power of attorney or financial power of attorneys in place?
Well, then, I mean, there's a very expensive process called guardianship proceedings where you get appointed over guardianship over property. And that's very expensive. It takes time. So meanwhile, bills are going left unpaid. And so no one has legal authority to pay your bills. And so that's problematic.
And how do people often feel on the other end once they've completed it?
Oh, I mean, it's like one of the true pleasures of my job because you can see people feel empowered that their estate plan is in order, that their wishes are going to be fulfilled, that their children and loved ones are going to be taken care of. It's you just one of the, for me, one of the most beautiful things that I get to participate in because you really see people feeling sense of empowerment that their assets and their family and loved ones are going to be taken care of.
Well, it's good to know that at the end of this huge painful process that people do feel good about it. They feel peace of mind, clarity. I find that with financial planning as well. The process itself sometimes is not that, I mean, I try to make it as fun as possible, but it's still it still can be really frustrating. But once they've done it, they just having clarity, you just move through life more efficiently and more at peace, I think.
And it's just one less thing that's weighing on you. And so that's part of this is that, whether it's your estate plan, your financial plan, having that clarity, knowing that you have a plan in place that gives you one less thing to worry about. We all have lots of things we're worrying about these days. And so knowing that you have at least one thing in order, your estate plan, which is vital, or your financial plan in order is really peace of mind. And that's something that I often find during the signings is that once that moment passes and the documents are fully executed, there's just this sense of relief. And yes, the process can be a little bit painful because part of it is confronting your mortality and confronting difficult issues and questions that are not pleasant. And no
Right.
no one wants to, essentially really deal with that, but we have to because we all died.
It will happen.
Yes.
I recently have kind of like realized that.
Yeah, no, we all have
Recently,
these moments.
at the age of 44, I'm like, wait, this is inevitable. Like,
Yeah, and we all have, I think that's part of life is we all have these moments where, we realize it, we forget it, we come back to it. And that's why, an estate plan, a financial plan isn't set it and forget it. Uh, this is what's right for right now. And then part of our practice is to send a reminder letter every 5 years to check in on with clients to see if something's changed because life evolves, our wishes evolve, and we want to make sure that your estate plan is staying consistent with the client's wishes.
right. And it's really helping your loved ones too, because the guardrails and parameters that you set out, if they're well thought out, everything should go much smoother for people in general.
Yeah, and I think that's one of the things that people like, that knowing that they've set up a good foundation to help their loved ones and their fiduciaries so that their plan can be implemented as easily and smoothly as possible.
Right.
And there's not gonna be unnecessary heartache.
And that's the thing about, working with estate planning while the planning is happening rather than post-mortem, which can be, I've done both. That can be very hard work. Whereas if the financial advisor and the estate planning attorney have been communicating all along, if something happens, we can just jump in and help right away.
Yes,
Right. Is there anything else you think people should know?
you should look at it as an opportunity. All the things we've discussed about is that it's an opportunity to help your loved ones and set up how you want your assets to pass in a controlled, smooth manner. And so this is an opportunity. It doesn't have to be looked at as a painful, well, painful exercise. It is a little bit of a painful exercise, but it's an opportunity to leave something joyous and good behind.
Got it. Just come to us. We will help you through this.
That's right. That's right.
And you will feel so much better afterwards.
You will. You will. Yeah. In some ways, it's like going to the gym or exercising. When you exercise, sometimes it hurts. But once you're done,
Right.
you're always relieved. This is the same type of thing as once you're done with this task, you feel good and relieved it's done. And knowing that your assets are going to pass in accordance with your wishes, everything has been clearly defined, and your fiduciaries will know what to do when something happens to you.
Excellent. Well, thank you so much for joining us on the show
No,
today. It's
thank
been a
you,
real
Marianne.
pleasure. And we'll put Micah's contact information and my contact information in the show notes. Thank you very much.
Thank you.